As the U.S. Supreme Court agrees to take a case challenging the ATF's rule on unserialized firearms, how's it going to impact Illinois, if at all, if the ATF's rule is struck down? Well, it's still going to be a bit before we actually have the case in front of the U.S. Supreme Court, but they have accepted it. Good morning, I'm Greg Bishop. Thanks for hanging out. It's Bishop on Air. Taking a look at the latest, and of course, this is a case that's gotten a lot of attention as you've got the various sides of this talking about violent crime and firearms that aren't traceable, and the plethora of firearms that are considered quote-unquote ghost guns being found in a city like Chicago by Chicago police. So you have here, ultimately what happened is an administrative rule that the ATF put in place concerning lower receivers and whether or not an unfinished lower receiver is considered a firearm. Because if you have, the lower receiver of, say, an AR-15, it needs to be milled, right? It needs to be drilled out appropriately if it's only 80% complete to get it to be 100% complete. And within the Second Amendment community, there's a large space for those who like to make their own firearms. And the ATF, as I checked previously on their website, even said that, unserialized firearms are legal, and you don't have to have a serial number if it's something you made for yourself. So interesting to see that language. And how it could be interpreted as this case proceeds. So privately made firearms. Here's what the ATF, the Bureau of Alcohol, Tobacco, and Firearms, has to say about privately made firearms. So if you go to the ATF's website, you can pull this up yourself and see this language that they have of what privately made firearms are. So pull this up on their website, atf.gov. And it says, privately made firearms are firearms including a frame or receiver that have been completed, assembled, or otherwise produced by a person other than a licensed manufacturer. Privately made firearms are also made without a serial number placed by a licensed manufacturer at the time the firearm was produced. However, not all privately made firearms are illegal, and not all firearms are required to have a serial number. ATF's compiled some information on the different types of privately made firearms and things to consider while owning one. So different types of privately made firearms categorized into different groups. There's 10 types of privately made firearms: pistols, revolvers, rifle, shotgun, frame, or receiver. Machine gun conversion device, destructive device, machine gun, firearm silencer, and any other weapon. And here are examples that you can see. So it kind of shows all the different types of privately made firearms. And I think a big question is the frame or receiver component here that has people, ultimately questioning what the bottom line is in this case. So the ATF goes on to say things to consider: individuals who make their own firearms may use a 3D printing process or any other process as long as the firearm is detectable as defined by the Gun Control Act. You do not have to add a serial number or register the privately made firearm if you do not engage in the business of making firearms for livelihood or for profit. So essentially, again, what this spells out is, you can make a firearm at home just as long as you're not transferring it to somebody else if it's for your own use. So getting into the weeds here, challenges involving privately made firearms. The ATF says privately made firearms are commonly referred to as ghost guns because it can be difficult to track them. Investigating crimes involving unserialized privately made firearms can create difficulty in tracing the origins of the firearm and linking them to related crimes. From 2016 through 2021, there are approximately 45,240 suspected privately made firearms reported to ATF as having been recovered by law enforcement from potential crime scenes, including 692 homicides and attempted homicides. These issues have led to some states passing additional laws related to privately made firearms. and those states include the state of Illinois. So that's a little bit of what the ATF has to say about privately made firearms, and they categorize these, and even gun control groups have gotten this into the lexicon, calling them, quote, ghost guns. And there's an interesting thing here, too, in this overall conversation. And if you guys have at all followed Cody Wilson's work, he is kind of considered the grandfather of 3D printed guns. It's been a decade plus since he had, I think it was called the Equalizer. I'm not sure what that first firearm he made was. But it was just a plastic single shot, polymer type of firearm that he made. And then it evolved from there with other 3D printing types of technology. And he would make available the schematics, the computer-assisted design files. These are just, like files that you can get on like a PDF or a Word document. These CAD files he made available for all of the designs that they would come up with, kind of like open source of sorts. And if you recall, and this has been years ago, he had the federal government come down on him, trying to prohibit his company from making available these documents, which, not only raised the issue of Second Amendment rights to keep and bear arms, but it even got into the issue of First Amendment rights, because, again, these are just documents that he was sharing. But the concern was that, the other actors, bad actors, opposition states could possibly get access to these things. So an interesting conversation to have about all of that. And that's totally tangential to what's going on with the case that the U.S. Supreme Court has agreed to hear when it comes to the ATF's rule on so-called ghost guns. And I think somebody who can really spell this out for us is Hannah Hill from the National Association for Gun Rights. She posted this on X yesterday, kind of explaining a bit about what to expect with the U.S. Supreme Court accepting the Garland v. Vanderstock case. And let's go ahead and hear it. Got that pulled up. Give me 2 seconds, get this where we need it, and unmute that tab so we can hear Hannah explain what exactly this case is going to mean for the Second Amendment community.
Hey, y'all. We got some great news out of the Supreme Court this morning. The Supreme Court granted cert in a lawsuit challenging the ATF's ghost gun rule, which was more or less a backdoor ban on home-built firearms. And they did that by redefining what a firearm is under federal law to include 80% lowers. And that way, basically, FFLs couldn't sell them unless they're serialized. And anytime one fell into their hands, they had to serialize it, like if they brought it in for repair overnight or something like that. So this is excellent news for the Second Amendment. What this means for us is that the Supreme Court is finally taking seriously the many instances of ATF overreach when it comes to the Second Amendment. That said, this is an administrative law case. This is about whether or not the ATF went beyond the statutory definitions that Congress passed and acted beyond their executive mandate. So that means that for cases like ours, where we're challenging the Colorado ban on home-built firearms, there's not going to be necessarily an immediate impact because they're challenging whether the ATF went beyond their statutory mandate. We're challenging whether a state may, under Bruin and the Second Amendment, outright ban home-built firearms, which is what the state has done. So still, it's excellent news for the Second Amendment. The ATF has been out of control for years, especially that only ramped up under Joe Biden, although it didn't start with him. And this has been long overdue on the part of the Supreme Court. So we are thrilled to see this, and we look forward to seeing what the Supreme Court says about it.
So, here you've got Hannah Hill from the National Association for Gun Rights talking about what kind of impact this will have in this space. And she mentioned it may not do anything for Colorado's laws. And they have a case challenging Colorado's ban on homemade firearms. What about Illinois and the ban that was enacted a couple of years ago now? Let's take a look at that piece of legislation that was ultimately signed, and this is from the state of Illinois' website: serialization of unfinished frames or receivers. And again, this is Illinois law. This is the law that Illinois passed. So let's go through here. It talks about different definitions. What's a bona fide supplier, firearms dealer, federal firearms manufacturer, frame or receiver, it says, means a part or of a firearm that, when the complete weapon is assembled, is visible from the exterior and provides housing or a structure designed to hold or integrate one or more fire control components, even if pins or other attachments are required to connect those components to the housing or structure. For models of firearms in which multiple parts provide such housing or structure, the part or parts that the Director of the Federal Bureau of Alcohol, Tobacco, and Firearms and Explosives has determined are a frame or receiver constitute the frame or receiver. So maybe there you've got, if this ATF rule is struck down, could this possibly impact Illinois' law? So it goes on further to say, for purposes of this definition, fire control component means a component necessary for the firearm to initiate, complete, or continue the firing sequence, including any of the following: hammer, bolt, bolt carrier, breech block, cylinder, trigger mechanism, firing pin, striker, or slide rails. Then it goes into other definitions, talks about a three-dimensional printer, means a computer or computer drive machine capable of producing a three-dimensional object from a digital model. Undetectable firearm means a firearm constructed entirely of non-metal substances, a firearm that, after removal of all parts but the major components of the firearm, is not detectable by walk-through metal detectors calibrated and operated to detect security exemplar, or a firearm that is included in major components of a firearm which, if subject to the type of detection commonly used at airports for security screening, would not generate an image that accurately depicts the shape and component of the firearm. Talks about undetectable. Unfinished frame or receiver means any forging, casting, printing, extrusion, machined body, or similar article that has reached a stage in manufacturing where it may readily be completed, assembled, or converted to be a functional firearm, or is marketed or sold to the public to become used as the frame or receiver of a functional firearm once completed, assembled, and converted. Also talks about what unserialized means, and goes on there with more definitions. But then it goes on to say 180 days after the effective date of the Amendatory Act of the 102nd General Assembly, which I believe we're now in the 103rd General Assembly. Keep in mind, they're 2-year terms, so we're in the I believe, second year of the 103rd General Assembly. So this measure passed a couple of years ago. Goes on to spell out even more of what the law spells out. Beginning 180 days after the effective date of this act, unless the party receiving the firearm is a firearms importer or federal firearms manufacturer, it's unlawful for any person to knowingly possess, purchase, transport, or receive a firearm that is not imprinted with a serial number by a federal firearms importer or federal firearms manufacturer in compliance with all federal laws and regulations regarding the manufacture and import of firearms, or a federal firearms manufacturer, firearms dealer, or federal licensed authorized to provide marking services in compliance with the unserialized firearm serialization process under subsection of this law. So again, how the case that the U.S. Supreme Court could hear, they've agreed to take the case up about the ATF's rule that people say is the ATF making law through administrative process. And the big question here is, can executive agencies in the federal government make law through the administrative rule process? And saying that unserialized, unfinished firearms components are considered firearms. So we'll be watching that and see how it impacts Illinois, if at all, when they do move forward and attempt to hear this case, whatever the outcome is going to be. And when are they going to hear it? It's a great question. Could be heard in the first quarter of next year, and maybe get some kind of outcome thereafter. Other updates on litigation against gun laws. No updates on the Southern District of Illinois federal case. They've got some deadlines coming up next month to get their expert witnesses in the challenge against Illinois' gun ban. But you've also got other conversations happening about parts, and I know Todd Vandermeide, will have to have him on again here soon to delve into the challenge that the federal firearms licensees of Illinois have brought forward, which really deals with the gun ban and gun parts that are impacted by the ban. So that's another element of this ongoing conversation. So no real movement in the Southern District case challenging Illinois' gun ban, but there will be some movement in that in the weeks ahead, with the prospect of a possible trial expected in July. So we have attorney Thomas Magg telling us that July 8th seems to be the date that they're going to move forward with the merits on that case. So there you have it. Just a little bit of an overview of at least how Illinois could be impacted by that U.S. Supreme Court case that they have agreed to take up. We'll be watching that, and you can stay tuned with us here with Bishop on Air. Just like, subscribe, and hit that notification bell, all right? Make it happen.